this next panel is going to be a conversation about the global SEP policy fight and the fight to really regulate the future, as we've called it. We're probably going to talk about China, Europe, the U.S., and a bunch of different topics that come up in between. Alden Abbott is going to moderate this panel, so let me introduce Alden to you. Alden is currently a senior research fellow at the Mercatus Center at George Mason University. Alden has done just about everything in IP in Washington, D.C. He's worked at the FTC. He's worked at the DOJ. He ran the IP area at Heritage, and then once he left Heritage, he joined the administration and became general counsel of the Federal Trade Commission. So Alden, pleasure to have you here with us today. So I'll just kick it right over to you, and thank you.
Oh, well, pleasure is all mine, Gene. Thank you for inviting me to your terrific program. We've already heard some big picture discussion of SEPs, and let me introduce you to our three highly qualified, I'd say renowned experts in patent policy who can really shed some new light on foreign and domestic developments. They're Adam Mossoff, sitting right here next to me, a professor of law at Scalia Law School at George Mason University, Patricio Delgado, vice president and head of pricing and FRAND compliance at Ericsson, and John Dubiansky, Senior Director, Intellectual Property and Standards Policy at Dolby Labs. And I actually met John when he was at the FTC doing important and very good policy work on IP. Despite, as we've already heard, despite their importance, SEPs today are under threat in key jurisdictions. And just to underscore their importance, you know, the concern about undercompensation, I'll take the prerogatives, the prerogative of being a moderator to say very briefly, one goes back about 15 years to the theory which was propounded by a number of economists based on work by Professor Lemley, I think Professor Shapiro and so on, that somehow the licensing rate, the FRAND rate should be very, very low, because there was this hypothetical bargain before a standard is set. They say, well, let's look at the first and second best standards. If the second best standard is only tiny bit inferior to the first best, and then the first best gets anointed for the standard, what's the fair royalty going to the first best? Tiny, just a marginal difference, a tiny sliver of difference between that and the second best. And anything beyond that they get is monopoly rents that are earned because the standard has conferred these unfair monopoly profits. So you should really take a very narrow view of what the return to SEP holders should be. Now, Professor Dan Spolver, one of my favorite economists, professor at Northwestern, has pointed out that this is really nonsense. He's done an excellent book called The Case for Patents, which looks at studies the patent system and points out the importance of the quality of standards in order to spread technology throughout different layers of distribution and different parts of the economy. And to have high quality standards, you need an incentive to can work with the standard setting body and offer up your technology, including your patents. If you get a very low return, you are going to flee from that. And what's going to happen? You're going to have inferior standards, a slower rate of uptake of technology, and that's going to hurt consumers, it's going to hurt producers, and indeed slow innovation and economic growth. And I think he does there's been some empirical work, you know, I won't talk about that at all, but I think Professor Spolver makes a lot of common sense. But again, I think certainly in the United States, a big problem we've had with SEPs has been this narrative that was cooked up 15 years ago, unfortunately bought into by some of my former colleagues at the FTC, and has really done a lot of harm. So now let's move on to different parts of the world. So let's start now with the European Union, which, as we've heard, is considering sweeping new regulations for the licensing and litigation of SEPs, and it could have a real work on an influence on evaluation of SEPs. But at the same time, ironically, the European Union continues to march forward with an unfair trade practices case against China at the World Trade Organization, asserting, quote, Chinese policy is extremely damaging to innovation and growth in Europe, close quote, because European technology companies are deprived of the possibility to exercise and enforce the rights that give them a technological edge, according to the European Union. Now, more recently, the PTO, Patent and Trademark Office, held a public listening session to hear from industry leaders on the topic of standard essential patents. The event was specifically related to the USPTO's effort to obtain stakeholder input on questions regarding proposed international standards presented in recent Federal Register notice, as well as strategies identified in the White House's National Standard Strategy for Critical and Emerging Technologies. Now, I'll direct initial questions to each of the three panelists and invite their colleagues to respond. We'll then engage in a free-form panel discussion to try and figure out why bad things are happening in SEP space and what might be done about it. Now, our presenters have strong views, particularly Adam here, and I'm not shy to talk about them and express them eloquently. And so I think it's going to be fun. So time's short, so let's get started. So first, to lead things off, in 2021, the Biden administration withdrew a 2019 Trump administration policy statement that argued SEP holders should be entitled to seek injunctions, among other things. The Biden administration's draft 2021 policy statement, which, in my view, problematically sought to micromanage SEP licensing negotiations, fortunately was withdrawn in 2022. So now, at least officially, there is no guidance from the administration. Now, Adam Ossoff, in late September 2023, PTO held its listening session I referred to on SEPs. What, if anything, good, bad, or indifferent, do you think came out of that? Where do you think Biden SEP policy is headed? And after that, we'll hear reactions from John and Patricio. Adam?
Yeah, thank you, Alden, and it's a real pleasure to be here. Thank you to Gene and to IPWatchdog for having me, and always delighted to continue to be a rabble-rouser about town with my very strong views, which Alden is correct that I don't withhold on. So the listening session that was held at the USPTO in late September largely, replicated what we have seen in comments and listening sessions held for the past 15 years on this topic, with the usual suspects from big tech and their various policy organizations that they fund and support, continuing to push the theory as eloquently described by Alden, a patent holdup theory, this academic theory, and royalty stacking, which has not been confirmed in the empirical evidence and in any data from the marketplace with respect to the licensing of not just standard essential patents generally, but of any patents for that matter in the innovation economy. And it was a little odd because it was originally characterized just as a listening session, and then the people who could speak at the listening session filed some written comments, and then the USPTO kind of decided we want other people to submit comments. So, and I was unable due to a conflict to participate in the listening session, so I was able then to organize some comments, of which Alden joined, very thankfully, that were co-drafted along with Jonathan Barnett, in which we kind of explained that, again, there's zero actual marketplace evidence. In fact, the evidence is actually contrary to the patent holdup theory that, the theory predicts higher prices lower market entrance, lower innovation, and of course we all know that these supercomputers we carry in our pockets, in which we share videos of cats riding Roombas on, have actually grown amazingly in terms of their innovation. The quality adjusted prices have actually dropped at a faster rate than even other sectors in the innovation economy. So it's a little unclear what is going to come out of this or why the USPTO is doing this. I'm a little worried, if only because the USPTO is asking a lot of questions about the role of SMEs, small, medium enterprises, and startups, which was the same questions that was being asked by the European Commission 2 years ago, which is what led to their proposed massive regulatory regime that John and Patrice will be talking about in a moment. So they might be heading in that same direction, at least if these initial indications suggest this. But the hope is not, and we need to stay on point and continue to remind them and submit comments that they need to engage in evidence-based policy making, not policy-based evidence making.
Great, that's a great introductory set of comments. John, any reactions?
Certainly. So I certainly do agree with everything that Adam has said. I should note that Dolby also participated in filing a comment to the proceeding as well. So I can speak a bit from our perspective on it. First, I would say I'm actually a little bit heartened by the overall context of this call for comment, if for no other reason than when historically the agencies have looked at this, it was driven by the antitrust authorities. The policy statements were coming out of the DOJ and PTO, and then later with NIST as well. The FTC was very prolific as well in issuing a lot of guidance. And that's inherently informed by a worldview of being an antitrust enforcer. And if you look at the theory of holdup, for example, it really got its genesis not just in the papers that came out in 2007, but also that came out at the same time as the Rambus investigation and also a set of hearings as well. And I think there was an inherent skepticism of IP enforcement in the standard setting context because it was being discussed as basically the harm to competition that flowed from anti-competitive conduct, which was basically fraud during the standard setting process. So it is nice to take a step back from that worldview and have NIST in particular have a heavy say in what's being said, because the call for comment was contemporaneous with a call for comment on the NIST National Standardization Strategy. And I think that document's very healthy in that it's looking at standard setting really from a national competitiveness perspective, from a technological innovation perspective as well. And it articulates something which has been lost for many years, which is the fact that in the United States, our approach to standard setting has been private sector-led, rules-based, and this model has served us very well for a very long time. So I think getting that out as a starting point is good and healthy. I also think that the document has articulated the role for IP, which is to incentivize participation in standard setting. And participation, broad participation, is one of the 4 pillars of the National Standardization Strategy. So at least in the framework, there's a recognition that SEPs and licensing are important and that they drive innovation, and that this is ultimately aligned with the goals of national competitiveness. The question, of course, is, as Adam indicated, will private interests and particularly the lobby on behalf of implementers that has for so many years espoused this worldview of holdup, will they hijack the conversation and bring it back into the realm where it's traditionally gone?
Well, that's a slightly hopeful comment, and one is reminded that when Pandora opened her box, the one thing that didn't fly out that remained, we're told, was hope. So let's hope you're right when you strike an optimistic tone. Patricio?
I guess my reaction was similar to John's in the sense that I felt neutral about the call for comment. I thought it was a reaction to what other jurisdictions were doing and how U.S. policy should react to that kind of in a positive way, because the last we'd heard was this retraction of this policy statement, right, where they said, well, we trust the courts to get it right and to guide on FRAND, and we don't have to sort of influence the process anymore. And so I felt like when they were calling for comment, it was a reaction to other jurisdictions really intervening and sort of a request from the U.S. government on how can we step in and help to push back on these kinds of interventionist efforts by other jurisdictions. So maybe that's a little bit naive, but that was the way I took it when I saw the call for comments.
Well, we'll see. Again, a little bit of hope. So, John, because you have been involved in European Union SEP-related issues, and how does, and I'll just confess too that I and my colleague Christine McDaniel at the senior economist at the Mercatus Center filed on this before the European Commission, raising questions about this proposed regulatory procedure. But anyway, for those of you who are interested, I don't know, there are probably hundreds of comments, but John, how does the European approach to SEP legislation compare to the way the U.S. has addressed these issues? Also, John, one area of the European proposal has been particularly controversial is the aggregate royalty determination. Show us the money. How high should those aggregate royalties be? What are the concerns about this provision? And obviously, I want to hear additional thoughts from Patricio and from Adam.
Great. Well, thank you, Alden. So I actually am currently engaged on behalf of Dolby with the European legislatures on this issue, and actually returned from Brussels last week, where I was speaking with stakeholders over there. And in terms of context, what we're seeing right now is actually a legislative proposal, or really a bill, passing through the European Union's Parliament and the Council of Member States. How we got here was, as is normally the case, the European Commission, which is the administrative executive branch of the European Union government, has issued a proposal into the legislative process. And that proposal was probably 5 years in the making, I guess, if you want to think about when it really started in earnest. And the European Commission started looking at SEP issues from a research and, I guess, more of an empirical perspective in 2017, which is right around the time when I think the world was moving on from the injunctive relief discussions that ended up culminating in the CJEU Hawaii VCT decision, and started looking at transparency and other aspects of standard setting. That set into motion a very long fact-finding process by the Commission, focused a lot on, I'd say, transparency in various aspects of the standard setting and licensing process. And then ultimately they issued a proposal earlier this year which went far beyond the transparency measures that those of us who were following it expected. There are various pillars to the proposal. Four in broad strokes. There is a disclosure requirement, which is very similar to the disclosure requirements at ETSI in general concept, certainly not in execution, where SEP owners must furnish information regarding their SEPs to a centralized, publicly run database. There is an essentiality check requirement where when identified SEPs are registered, the EU administrative agency, in this case the EU IPO, will now perform a random sampling of those patents for essentiality checking purposes. Of course, due to somebody's intervention, there's also other mechanisms, like any implementer, for example, can request or denounce 100 SEPs every year for essentiality checks and put that in the process as well. But in theory, it's a random verification of the self-declaration of essentiality. Then we move into two provisions that are not transparency measures in my mind. There's a conciliation or mandatory dispute resolution process, and there's also an aggregate royalty provision where the EU IPO will either publish announcements of aggregate royalty by SEP holders if they choose to self-declare, or in a more controversial aspect, they will actually convene a panel of experts who will issue an opinion on basically a maximum aggregate royalty for a standard. So in terms of your question about how this compares to the American approach, I think fundamentally there's just a fundamental philosophical difference between what Europe's doing and what the U.S. has done in the past. the U.S., as reaffirmed even in the statement of withdrawal of the 2019 policy statement, ultimately views FRAND as a matter of private contract, where the terms of the FRAND obligation are set by the language of the contract entered into voluntarily by members of the standard setting process, and they're construed by the courts. And I think we see that, in Erickson v. D-Link and other cases where this is really viewed as a matter of private contract. What Europe is doing is they are legislating FRAND. I mean, the Article 1 of this legislation states that this will apply to any patent that's been declared essential to a standard with a FRAND commitment. And then you go on, you have 72 articles of obligations that are placed upon you if you make that commitment. So philosophically, we're moving far away from the rules-based, private sector-led approach to standardization that the U.S. is currently reaffirming, and we're moving into this very prescriptive regulatory regime where the government is just going to regulate what you're agreeing to do by private contract. Further to this, the American approach historically, even though I think we're all skeptical of it to some extent, has been driven by antitrust enforcers engaged in ex post enforcement when there is viewed to be specific articulable anti-competitive conduct. We are now moving into an ex ante regulatory regime, which I think is a huge difference, particularly on issues such as holdup. For example, in the context of holdup in the agencies, it was actually a factual finding that needed to be made. I'd like to point out the fact that in Rambus, for example, the FTC only alleged there were 3 standards that were being held up, and actually the commission found that one of the 3 didn't hold up because there was no lock-in. So to move beyond that and have the presumption that holdup is endemic is a huge issue. And that's actually one of the real controversial points right now in Europe, which is, does the commission need to make a further finding for specific standards that there's a problem? Because right now they simply said everything is going to fall into this. Yeah. And then finally, the other point I'd raise is just with regard to the aggregate royalty provision. They have moved from what on its face was a transparency measure, where I think a lot of the stated motivation was that it would be really useful if there was information about rates that are being charged to have it available to implementers. And they have slid in a tribunal that will issue an opinion on aggregate royalties and maximum rates. I raised several concerns with this. The first is that there's been a bright line in what we've been doing in the U.S. when it comes to price. I mean, even when I was at the FTC, when you were there, Alden, and before, most recently, we were talking to our partners internationally about excessive price and about basically the fact that even if we're going after injunctions as a matter of conduct, we drew the line at any sort of enforcement, in particular jurisdictions where they were looking at charging excessive pricing as a antitrust violation. And the view was that you focus on conduct, but price is something you leave to the marketplace. So conceptually and philosophically, moving into price setting, no matter how you look at it, is a huge step away from what we've been doing in the States. And then the second point is that this invites a lot of danger for regulatory creep. If you look at what the commission has said, they've got thousands of pages of supporting documentation. When you get to about page 100, they start talking about ex ante incremental value as being the appropriate benchmark to be used by the tribunal, which is exactly the point that Alden raised earlier about this is a measure that's promoted as a means of curing holdup. So there's just a lot of danger from moving these pricing decisions away from the market into the regulators' camp.
So maybe I can add to that and draw the things that bother me the most. So in the U.S., when the DOJ and the PTO, when they withdrew that policy statement, they said essentially that case law had advanced enough and they trusted the courts, private parties, to try to resolve their differences, and if not, they would trust the courts to enforce the FRAND commitment. And when you start reading this regulation from Europe, you see in the very first page that they don't trust the courts in Europe to resolve FRAND disputes. And so they feel like they have to intervene because the courts can't do it. And that's shocking from the start. And then what you see, is that they want to regulate an industry that is extremely large and extremely complex. So they want to regulate every patent that is related in any way to any standard on any standard compliant product. And it's huge. This is like a huge, huge, huge task. Okay, they want to do that through, this regulation. And then you see, well, how many resources are they willing to put to do this? And the latest I've heard is that they're willing to build up a group of 10 full-time employees to do all of this. And that they will, and then what I've heard is that they will outsource what those 10 employees cannot do. They will outsource that to someone. We don't know who. These are quasi-judicial activities these people will be doing, right? Like they'll be judging whether a patent is essential. They'll be trying to regulate what the right price is. So they're quasi-judicial activities. We don't know who's going to be doing that. We don't know how much time they're going to be spending on it. And so it's sort of like they're throwing this half-baked idea out there to industry and wanting to get support. And we just have no confidence in the level of rigor that they're going to apply, or in the level of due process. It just doesn't seem like something that a reasonable person can buy into. So that's those are the things that when I read the regulation and I compare it to the U.S. system, I'm sort of like wondering what's happening over there.
Right. Well, this is sort of more this sort of European tradition of belief, and there's this philosophy of belief in the role of the state and expertise of the regulators, sort of ordered liberalism. Order liberalism is sort of a German term. It also, in my mind, reflects what Friedrich Hayek, the economist, called, a pretense of knowledge, that the experts think that they have superior knowledge. And to top it off, correct me if I'm wrong, but this office that's been assigned a task, doesn't really have much experience at all in patent law and policy. Is that correct?
Correct. No experience with patents, no experience with standards. So, it just adds to the sort of concern over rigor that this is being applied with this regulation.
Yeah.
Adam, you want to add fuel to the fire?
Yes. Well, I think that Patricio and John have very effectively explained. In fact, it was impressive how well you summarized what is thousands of pages of this massive regulatory regime. And I think both of you really effectively described the shift from the courts to regulatory agencies. And so, and John and Patricio expressed concern about regulatory capture, and I would actually propose and suggest there already has been regulatory capture. And so I think the context here is really important. If we look at the historical context, starting with, as Alden said, starting with this academic theory of patent holdup and royalty stacking that had been advanced by Mark Lemley, Carl Shapiro, and Fiona Scott Morgan and others around, starting in in the early 2000s. And they created all of these theories. And the first place that they went with was to the FTC and to regulate antitrust agencies. But they also tested these theories in court. And they continually pushed litigation. In fact, there's been, the very massive amounts of litigation that implementers now complain about was created by them pushing patent holdup theory, royalty stacking, also level of licensing requirement. Does FRAND require SSPPU versus device level licensing as the base? Portfolio licensing, is that a violation of FRAND? Or do you have to have, and then geographic level license, or worldwide licenses are FRAND? These are the issues that they have been litigating against SEP owners for the past 10 or 15 years. And repeatedly, the courts have been saying, show me the evidence, because these are all academic theories. And repeatedly, the courts have consistently, across the board, have been rejecting this, and consistently have, in response to the implementers pushing these theories, have been saying, no, you're the ones engaging in holdout. Under the Huawei decision, we are now in the tens of 30, 40 decisions now in multiple jurisdictions: Germany, England, Netherlands, even China and India, Brazil, that have found implementers to be engaging in holdout in negotiations in violation of the FRAND commitment, and thus affirming a request for an injunction or ordering injunctions in favor of SEP owners. And so what you have then is 10 or 15 years of them failing with the branch of the government that has to follow rules of evidence and due process. Well, what branch of the government doesn't have to follow rules of evidence and due process? Right? The executive, the agencies, or the legislative, right? So, and those branches, they can capture. They can capture very well in a way they can't capture judges, because judges are required to follow the evidence and follow the law. And so since they have failed in courts, they have now shifted back to the agencies, and especially since the European courts have been really impressive and really effective over the past 10 or 15 years. And I emphasize this because American lawyers and judges seem to be oblivious to this. I've been really surprised when they say, well, an injunction has never been issued for an SEP owner. You hear a lot of American commentators say this, and even U.S. judges say this, and it's just false. We're 10, 20 cases which this has happened. And so I'm not surprised that they're expressing displeasure with the courts or mistrust of the courts, because you can go to an agency official and say, hold up, and SMEs are being holed up. And you can go to them and argue these theories. They don't have to follow rules of evidence. They can accept that and then act on that without any regard for due process or evidence.
Capture, that's certainly an interesting point, and there's a huge economic literature, of course, on that, stemming back from Stigler's famous article, The Theory of Regulation, dating over 50 years ago. Now let's move east in our traveling roadshow to China, the source of major policy concerns, including in the SEP area. So in February 2022, as I mentioned earlier, the European Commission launched a complaint against China concerning the granting of anti-suit injunctions by Chinese courts. Anti-suit injunctions restrain SEP owners from enforcing their patents in foreign courts, reducing the value of their SEPs. More recently, in June 2023, China's antitrust authority released a draft guideline on SEPs, and the draft imposes a number of requirements on SEP holders and promulgates factors dealing with whether SEP owners have engaged in excessive pricing. You already heard about excessive pricing. This suggests a risk that the Chinese government may be planning to, quote, crack down, close quote, on SEPs, especially foreign ones. Adam, what's your take on these developments? And as a practical matter, what actions can the U.S. and the European Union take to discourage the Chinese from these policies that effectively may devalue SEPs, especially non-Chinese ones? And then I'll ask for the views of John and Patricio, of course.
Yeah, thank you again. And so, interestingly enough, the Chinese activity with respect to anti-suit injunctions has largely declined since China overplayed its hand in the Samsung versus Ericsson case, in which I played a role as an amicus, in where Samsung, a South Korean company, in a dispute with Ericsson, went to the ironically the court in Wuhan, now famous for other reasons, and got an anti-suit injunction against Ericsson. On
Christmas, no less.
Yes, issued by the Chinese court on Christmas Day. So my Christmas season was ruined too, because I participated in the amicus filing in support of the TRO that was immediately asked for. I felt really bad, even more bad for the attorneys who were called back from their families on Christmas Day. And then the case that they were trying to get the anti-suit injunction against was the Eastern District of Texas, and they were not having it, and understandably so, because you have here a court it was the anti-suit injunction. It was a secret lawsuit. There was no notice of it. There was no service on Ericsson by it. It was you can speak, but I'm happy to speak very bluntly about it.
I think we got I think we got an email, like a Gmail email with a complaint.
Yeah.
At some point.
But the actual hearing for the anti-suit injunction was ex parte. It was as you said, and then the anti-suit injunction issued that day, and of course then the Eastern District of Texas issued rightly its anti-suit injunction, they caught a lot of flack for this. I mean, because I think it really made clear what China was doing, that this was industrial domestic policy, this was abuse of their court system, this was abuse of process. I mean, across the board. I mean, no due process, no notice, ex parte proceedings, trying to shut down a U.S. court who does follow due process in U.S. proceedings, and so my sense is there haven't been any anti-suit injunctions. I could be wrong about this, but since then, but that's because they moved it more to into other domains of their governance structure. So they are doing it now kind of more quietly through their antitrust agencies and through simple just litigation matters more generally without actually anti-suit injunctions themselves. But China is continuing to put pressure on foreign SEP owners, devaluing their SEPs for the payment of license rates for their domestic implementers. In fact, the United States and many other countries has joined the EU's complaint at the WTO against China for exactly these reasons. And I think we can continue to put pressure on China, call them out for their abusive process, their abuse of their institutions, their failure to follow due process, and the fact that what they are using here are tools to advance their domestic industrial policy, and that they're abusing courts, they're abusing what should be neutrally applied laws for this purpose. Calling them out for this and exposing this, I think, can have some role. They do, at the end of the day, care, I believe, in some respects about their stature in the international community, as evidenced by their no longer issuing anti-suit injunctions after the Samsung v. Ericsson debacle.
John and Patricio. Patricio,
no, I can go next.
Yeah.
I thought you said, Adam said a lot of things that I'm glad you said. So a couple of things to add to what you said. One was that although they have stopped issuing anti-suit injunctions, they are still arguing for their right before the WTO to issue anti-suit injunctions. And so there's still that latent threat, I guess, that they could still revive that. Mm-hmm. The second thing is with regard to competition law and using competition law to affect pricing and whatnot. The funny thing is, that, at least from my perspective, is, when you use competition law, a threshold issue is that the party that is being accused of violating competition law has a dominant position. They can control the market. They can turn off the lights if you don't agree with them. And what's funny, I guess, in the licensing industry is how difficult it is to actually license Chinese companies. And so, if you had such a dominant position, you would much more easily and pervasively be licensing, but you're not. Mm-hmm. I think that's one thing. And then the second thing is that China's come out and said that they will enforce the FRAND commitment. As a contractual matter, they will enforce it. I think that's gone up to the Supreme Court. And in light of that the courts are willing to enforce the FRAND commitment, then there is basically this countermeasure to any power that the patent holder has, because they can't self-enforce an injunction. They need to go to the courts, and if the courts are willing to enforce the FRAND commitment, then where is the market power? Where's the dominant position? So, they keep building all these restrictions and requirements based on competition law, but I'm always in the back of my mind wondering, how are they satisfying that threshold issue to make this body of law applicable? And so, going back to your question, Alden, on what the U.S. can do or other governments can do, I think just asking for, rules-based analysis, due process, really focusing on the requirements of competition law in order to pursue competition law matters, more transparency. I think these things would be great.
Well, if I could perhaps return to a European paradigm for a moment here, as I'm giving that a lot of thought these days. One thing that I think both Adam and Patricio have tacitly acknowledged while talking about what China's doing is that they are ultimately still applying ideas around governance here that have emerged from the West. And the abuse of dominance is something that's come from more of the European tradition. The treatment of FRAND as a matter of contract has come from the American perspective. But one thing that we can do, or that Europe can do right now, is really lead by example, or not lead by example as well, because ultimately they are talking about introducing a paradigm shift again, where on the one hand you have things such as price now being an explicit matter of regulation, without any showing of anti-competitive conditions or dominance. And then on the other hand, if you look at the justification for this, if you go back through the actual cost-benefit analysis that the Commission's put forth, if you read between the lines a bit, they go through in every member state and they do a cost and benefit, and they're pretty explicit saying that the benefits of this are going to be felt by implementers and the costs by SEP owners, and then they do a tally. Well, I think it's very dangerous if you find jurisdictions starting to go ahead and do that tally and come to the conclusion they're a net implementer, and then justify policy, especially ex-ante regulatory policy, as a result of that. So these are perhaps some bright lines that really haven't been crossed before, and I am concerned, to use the metaphor of the Pandora's box, that if we open this up, then other jurisdictions are just going to follow suit, particularly those that have had, I think, a history of trying to take the framework that's already out there and move it in a certain direction.
I'll just quickly say, do you think that's part of a Chinese policy or plan to sort of make Chinese standards sort of dominant world standards? Is that tied into all this? I'm just curious. Anyone? Adam?
Yeah. I don't think we should ever drop context that when we're talking about China, we're talking about an authoritarian regime. Right? We're not talking about a country that respects due process. We can ask them to do so. We can appeal to them to do so, but that is not that's not their government structure. And not only is it an authoritarian regime, Xi has become more authoritarian in recent years. They have had a turn towards more authoritarian policies and an approach to their governance. And so certainly, in the same way that their patent system and their patent laws have been very much tied up with their domestic industrial policies of promoting their growth, I think their patent system also plays a broader role in their geopolitical strategy, in which they see themselves as a competitor with the United States. And I think they have long seen themselves as a competitor with the United States. I don't think this is some recent, decision they've made. I think that this is something that they have viewed themselves as for well over a couple decades, and we are only now just waking up to this reality of how weakening our patent system when we are facing a global competitor is one of the worst things that you can do. And even what would be worse than weakening our patent system is when you're facing an authoritarian regime and competition from that authoritarian regime is trying to beat that authoritarian regime at its own game by adopting top-down regulatory measures and other types of authoritarian type doctrines that that they can do much better than we can, because that is not our system. Our system is market-based, protection of individuals, protection of private rights, contract property, and the rule of law. Mm-hmm. So I do see some concerns here. Unfortunately, what makes this conflict with China very different from past conflicts with authoritarian regimes like the Soviet Union and others is, we are very economically bound up with China now, right? The largest, most valuable U.S. company, in fact, the largest, most valuable company in the entire world in terms of its market cap, right? Apple has now, used to have 100% of its products made in China, and now has been able to successfully reduce that down to 95%. And that presents itself a serious problem for us, not as a matter of economics and as a matter of policy as to how do we address that. And so we have to take that, recognize that, and as we kind of have these conversations about how do we address kind of this global competitor who is challenging us and is very strategically engaging in efforts to take over standard development organizations and other types of activities that we need to be aware of and we need to counter very effectively.
Great. Okay. Well, now final lightning round. All three of you just chime in, pithy comments. First, what domestic policies could a new administration establish to help SEP holders obtain a reasonable return on their innovations? Could they, for example, reestablish a 2019 Trump administration guidance document on SEPs? Could they reinstate the Trump administration's new Madison approach to the patent antitrust interface, which treats SEPs like all other patents and states that SEP holders should have a robust right to seek injunctions? Any other specific suggestions? Take it away.
Stronger remedies, faster time to relief.
I agree. I would say revisiting eBay.
Okay.
Same thing. Return of the presumptive right to an injunction on a finding of infringement of a valid patent.
Okay, great. Short and sweet. Second, could specific legislation on SEPs be helpful? If so, what should such legislation try to do, and should it be tied to other patent legislative proposals? Anyone?
Start with
You guys start
All
this.
right. No on specific legislation with respect to SEPs because that represents a balkanization of our patent system. We should continue to proceed with a neutral platform of core property rights in which people can then take their property rights out into the world and contract with them in SEP context or patent pool context or in other types of commercial contexts. That has been the key to the success of the U.S. patent system as a driver of our innovation economy.
I agree. I'd say that FRAND has been treated as a matter of private contract and is appropriately kept that way in the courts and in private contract. Regarding legislative fixes, I would say that to the extent there is a legislative fix on injunctive relief, that would be one area that we could explore.
Yeah.
That'd be great.
And I agree as well. I wouldn't want to see fragmentation of the patent system so that there are different rules for different kinds of patents, because even if I get what I want in the United States, I may not get what I want, in the other countries around the world, and then you'd lose your ability to argue that there should be consistency across patent classes everywhere.
Okay, very good. Let's finish with a third question, which already addresses some of the points made about perhaps how one might address foreign jurisdictions and what their policy considerations. Could a new administration consider multilateral discussions with the EU and China regarding the treatment of SEPs? Could they consider filing a complaint with the World Trade Organization? Any other potential multilateral actions? And finally, how about potential U.S. trade law sanctions under existing authority to challenge discriminatory attacks on SEPs by China or anyone else?
We'll start with that. Let's say first.
Why don't you start, Adam? That's not a safe question for me.
Yeah, that's a big question at the end because there's a lot there. Should we always pursue all opportunities to ensure the non-discriminatory treatment of U.S. patent owners, but of all patent owners? And the answer is yes. If complaints at the WTO, wonderful, but one often wonders what comes of that in terms of the sanctions and things of that sort. Not much pressure at the end of the day results from that. And so at the international level, there's not much you can do aside from applying pressure and then making it very clear at minimum that at least with respect to U.S. patent owners and the shared interest between U.S. patent owners and European patent owners, that that other countries such as China should not engage or discriminate against them, should not use them as pawns in geopolitical policy or in domestic industrial policy, and that we should hold them accountable for that. Now, whether we do that through trade sanctions, targeted trade sanctions, or other types of responses, I leave to the to better minds to figure that out.
I would add one other avenue that the administration could undertake, which is really technical assistance and bilateral engagement with peers across the administration. I think, perhaps we've ceded a bit, but still overall, the U.S. has a great reputation as a leader in innovation and leader in the space. And certainly around the developing world, I think they still, we still have a lot to offer, particularly in younger agencies and younger administrations as they look at some of these technical issues. So I would add that as well. I think we're engaging internationally. When I was at the FTC on these issues, I think we should continue to do so as well.
I think the U.S. has a huge role to play internationally. I think the U.S. needs to continue to advocate for a rules-based system as opposed to might is right throughout the world. And I think only the U.S. has the leverage to try to enforce that kind of system on a global scale.
Yeah.
Right.
Actually, in a non-SEP context, like the things the U.S. could do is stop supporting waivers of patent rights at the WTO.
Right.
You know, I mean, whether it's pandemics or not pandemics, it's irrelevant. I mean, that destroys our ability to effectively make the case that you need reliable and effective protection of intellectual property rights that benefit everyone around the world.
And it's also reflects the concern that, well, after all, the statutory language suggesting that a patent is a property right, even if not all members of the Supreme Court are convinced.
Mm-hmm.
But it's important in terms of protecting property rights, because property rights and freedom of contract are key to with protection of the rule of law. They're key to market economies and really key to economic growth and innovation, I would argue. All right. Well, I think we're about out of time. Patricio, Scott, Freudian separate. John, Patricio, and Adam. I don't think Scott was lurking behind the chairs, but you all did a fantastic job, and I really appreciated your thoughts, and I hope the audience did as well. So if you liked it, let's give our great three speakers a round of applause.
Before I let them get dismissed and we go on, does anybody have any questions for the panel? Roderick.
Yeah, actually, I'd have a question, and let me say I really appreciate this view of the world, especially China just, isn't on my radar screen. As an American living in Munich, it's, the European regulation, of course, but China, so it's really nice to see that, there's a lot happening around the world, and you kind of have to understand everything in a global context. But I'd like to come back and make a short statement, then ask for your thoughts. To come back to John's presentation that this European regulation is somehow different from the US. Because when I first saw it, I was like, hey, this is the Garretson-Mopp decision coming to Europe, that 150 years ago, the Supreme Court set precedent that I think is still accepted in the US. You have a patent and you get the right compensation. That last year, some Munich judges who, they're among the most experienced in Europe with SEP cases, they pleaded for support like the Garretson-Mopp, that somebody helped them find the right compensation for the inventors. And here, it's important to know, and I as also a German patent attorney had to learn this, that under US law, the judge figures out, is it valid, is it infringed, what's the right compensation? Under German law, you have one court that judges, is the patent really valid? Another court that judges, is the patent infringed? And no court decides what's the right compensation. So these judges, they wrote an article last year, it was published in the most respected German journal, in German unfortunately, saying, what we need is somebody who does this evaluation for SEPs, what is the right compensation, in a way to align it with US courts that for 150 years now, the judge has the assignment of finding the right compensation. I wonder if you have any thoughts on this comparison of how the regulation will bring European law in line with US legal tradition.
So
I
go ahead.
Sure. I mean, I think first of all, I think it's one of the motivations I've heard for this regulation is dissatisfaction with German law on patents, and I think that the European process and also the competency of the Commission and their obligations under TFEU really needs to look more transnationally than that. And if there's an issue with law in one member state, that's not necessarily an issue that the union should take up. But I hear your point. I think I just raised in more of a philosophical observation, which is that post eBay, the U.S. has moved into a liability rule regime for IPR, and Germany remains in a property rule regime. And my personal view is that the most efficient way to determine how these things are priced is in a property rule regime where parties work it out after there's an injunction on the table.
Go ahead. I didn't know if you had more to say, but I had a quick comment, but if you...
I have a very quick comment about Gerritsen and stuff.
Yeah.
So if you want to go ahead, I can just conclude.
Yeah, I mean, Gerritsen, as you know, it stood for the principle of apportionment, right? That you have to, that your patented technology, what you receive as far as damages go, should reflect the economic value of the patented technology. And, you know, comparing that to what happens in Germany, I mean, under competition law in Germany, you are, to avoid a charge of excessive pricing, you do have to price in light of the economic value of your patented technology. So I do think that even under the competition law regime in Germany, that the courts are looking at that. And if you look at the specific cases that have come out in Germany over the last decade, you know, like the Nokia Daimler decision or whatnot, the courts are looking at comparable licenses. They're looking at, you know, practices from industry to try to understand whether the patent holder has provided an offer that is within the realm of what, you know, would be reasonable. So I guess maybe I take a little bit of issue with the premise that the German courts are not considering economic value in their analysis, as well as validity, frankly. I mean, we've been on both ends in Germany, and even though the German court does not decide the validity issue, they do peek at it, and it is a factor in whether they issue the injunction. So I guess I challenge the premise a little bit of the statement that you made, with respect, of course.
Yeah, and then very quickly, because I appreciate you actually said a lot of what I was going to say. That I think there is Gerritsen is I think somewhat of a misunderstood case now. I mean, it really simply just stands for a generalized recognized principle in remedies law and Anglo-American law that you are put in your rightful position by receiving the value that you should receive, and sometimes that is a portion of something else. But the question then is, how do you assess that? And the U.S. law is fairly consistent, and this was one of the issues that has been litigated under FRAND as pushed by implementers, whether you should have a top-down methodology or bottom-up. And courts, being evidence-based, have adopted almost universally a bottom-up methodology. The evidence of its market value tells us this, and the best way that we get at what is evidence of its market value is comparable licenses. And the EU regulation is a top-down methodology. It's let's set an aggregate royalty rate and then use patent counting to divide it up among all the different SEP owners as to what they would be their respective percentage shares. That's not what Gerritsen says, and that's actually even not what the law in the United States is as to assessing actually what is the respective value of your patented contribution to a final product.
Do we have time for one more, Gene, or
Sure,
should we
yeah.
close?
No, we can, Kurt.
Hi, everybody. Can you hear me? I just had one question about the legislative front because it looks like getting consensus at the SDOs is not possible given you have implementers and innovators there. Would there be a case for legislating mandatory arbitration?
Anyone?
Well, you do have consensus at the SDOs, given what the function of the SDOs is, which is they're standard development organizations. They're not legal entities, so these aren't patent pools or other types of institutional market structures that address legal problems. They address a technological problem and a market problem of interoperability and provide a solution that's more efficient than standards wars between respective private manufacturers, or a top-down kind of government regulatory approach. And so they actually, when you think of it, it's really impressive what that SDOs function as well as they do when they do bring all of the different people who have competing claims into their standard development process, who eventually do come to an agreement as to what should be the standard that they're going to propose for people to adopt. And so if you think about what the function of the organization is for, then proposing mandatory arbitration is, first of all, contrary to and is adding kind of, you're going to create contradictory demands within the institution as to what its institutional function is. But secondly, like I was just at a conference on Thursday, where a patent law conference in San Francisco, where someone asked a panel, "What do you think of arbitration?" And it was universal across the board. Everyone said, "I hate it." And I said, "Wow, that's really interesting." I actually raised a question. I said, "Because everyone is in favor of it." And I said, "Why are you opposed to it?" And across the board, they said, because you don't have, it's not transparent. You don't have protection of due process. The arbitrator doesn't necessarily have to follow rules of evidence. You don't get an appeal under the law, a same appeal as you would in a court process. And they said you end up with arbitrators who oftentimes don't fully understand the technology or the issues, and they just end up being like Solomon and splitting the baby. And so they said, so they all said, it's a far worse situation for us. And it was across the board on the entire panel. It was very eye-opening. And so I think that there's a sense of kind of a nirvana fallacy that we enter into about arbitration vis-a-vis courts, where we kind of hold up arbitration as this efficient, perfect process compared to the courts with all these problems and costs. And I really think we need to compare actually how it functions as an institution to actually how it functions, the counter institution functions here, courts versus arbitration.
And we're going to talk more about this on our panel tomorrow about the biggest impediments, but it seems like the biggest impediment is there's no timely resolution. There's no mechanism there. You've got to go to courts around the world individually. You never get that one solution. So I understand that arbitration has its shortcomings, but at least has a possibility that you could write, I guess, enough rules around that. And I'm coming back to a paper we wrote for IPWatchdog about how the U.S. government deals with its own property when it comes to siting antennas on federal property, or what they call pole attachments, or interconnections with the local exchanges. They have these rules. So apparently, as far as I can tell, the U.S. government has the power to legislate and understand these things. There just doesn't seem to be much motivation to do it here.
Industry, the idea of arbitration has been thrown around as a solution, and industry just can't get consensus. So anytime there needs to be consensus, industry can't get around it. I also have this kind of nagging feeling that access to courts is a fundamental right. It's like a fundamental human right, and so when you take that away in favor of something else, I guess I get this concern, that we should preserve our ability to have access to courts. And I think that's very important to preserve.
I just add that it hasn't. It's not the case that it's never been used. I can think of DVB, for example. They've got a somewhat unique IPR policy and a unique approach to IPR issues, but there is an arbitration component amongst DVB members as well. So, but that was something that was there at the ground floor when they created the organization, and it was definitely part of the MOU when the thing came up and when companies agreed to join as well.
Okay, well, thank you guys very much. That was a great conversation. Appreciate it.
Thank you.